when the Aboriginal Land Rights Act was proclaimed and commenced in 1983, the Act provided for a thing called a registrar. And the main reason that it did that was that it needed someone to register land claims. That role is still there today for me as registrar, and has been and should continue after my time. But the role's also changed a lot in those 30 years or so. And what's happened over time is it's changed because the Land Rights Act has been amended. So probably the first big change in the role was 1996, when the New South Wales Parliament said there shall be joint management of conservation lands between Aboriginal people and non-Aboriginal people, what we've kind of colloquially called the Joint Management Program, of which the mighty Mutawinji National Park was the first. And that required the registrar to keep a thing called the Register of Aboriginal Owners. So interesting, and has always been a bit controversial because it means individual Aboriginal people have to be registered. But generally people have seen benefit in that process because it's allowed people to make a very clear statement about their cultural authority in their country. So that is ongoing. We have a number of jointly managed national parks now, and we continue to do that. And at the moment, the two that I'm working on are the Mount Yarrawick Nature Reserve west of Armidale, which is a beautiful art site, and the internationally iconic Mungo National Park in southwestern New South Wales. Apart from that, day to day the registrar works with the New South Wales Aboriginal Land Council, works with the Minister responsible for the Land Rights Act, whomever that might be, and works on a daily basis with local Aboriginal land councils, which is, for me, the most rewarding, interesting and enjoyable part of the work. And that work is as varied as what local land councils might do. So the list of what thing called registrar does is in the Land Rights Act, and I would just summarise by saying the main ones are land claims, the Register of Aboriginal Owners, helping local land councils on a day-to-day basis, working with government on the Land Rights Act. And this is something which is going to be very important come the 1st of July this year, when some amendments to the Land Rights Act that went through the Parliament late last year commence. And that is, the registrar becomes more of a regulator of the corporate and individual behaviour of land councils. So I'm going to be interested to see how that change affects the relationship between land councils and a thing called registrar. Time will tell. So
what do you mean by that? Like
a
regulator, like what is that?
Sure. So for example, over time, if a land council falls apart for whatever reason, an administrator can be appointed. Or if there are matters going on which warrant questioning, an investigator could be appointed. The power to do those things to land councils, both NSWALC and local land councils, has always resided in the Minister administering the Land Rights Act. Come 1 July, in relation to local land councils, that'll be the registrar's job. Because the registrar has been able to stand away from that role, it's meant that the registrar has been able to be very much more an honest broker, if you like, between government administrators and land council members, and that's going to change. So that's something I think everyone needs to think very carefully about. So I go back in land rights scarily as far as 1990. And before that I'd been kind of mucking around in kind of industrial law and consultancy work and other bits and pieces, and I literally saw an ad in a newspaper. And I've said to people before I took the job at the Land Council, I reckon I'd met 4 blackfellas in my life. I was a Sydney boy from the western suburbs. I'd gone to university and had a head full of what the world should look like, but not really sure what to do with that. And I saw an ad, and it was an ad to assist the then New South Wales Aboriginal Land Council, whose office was above a hot bread shop in Moore Street, Liverpool, with sorting out what land they and local land councils may own. So essentially, going to the land titles office and working through the titles and figuring out where land was and what was owned. And it looked interesting, so I accepted an interview and I got a job. And they were very dynamic times, and I was far too young and naive to understand the import of that at the time. But what was happening was that the Liberal National Party government had come to power in 1988 after the Unsworth government was defeated, and it was the Rand government before that included Attorney General Frank Walker, who was the architect on the government side of the Land Rights Act. And they'd come to power on a party platform of repealing the Land Rights Act. So by the time I turned up there in 1990 to help work out land ownership, there was an almighty political bun fight going on about whether or not the Land Rights Act would survive. And so I was, in my naivety and enthusiasm, thrown in the deep end of Aboriginal politics in New South Wales. So I spent the next sort of 6 years of my time at NSWALC working very hard on the land claims process and increasing the number of claims and assisting local land councils and running a number of court cases on appeal with a number of lawyers around Sydney who cut their teeth on land rights and were very good to land rights, and building that up. And I think that period in the 90s for NSWALC I see as a real focus on accumulating land. We probably got granted about 2,000 to 3,000 claims in that time, some of them extremely high value, but I think as well as the land that was granted, what was most important was the precedents which were built up in the courts as to what land is claimable. And those precedents, including in 2008 with a High Court decision, have meant that the rules of land claims have been made very fair. So even when governments are unwilling or annoyed at needing to transfer land claims, the law has locked them into a very fair process, which is a great thing. So it's always difficult to say how much, but what I always tend to do is I say I can see particular land claims that were granted that gave local land councils an opportunity to participate in the economy and the society of New South Wales in ways they wouldn't have. For example, the Darkinjung Local Aboriginal Land Council North Entrance land claim, the Warramai Local Aboriginal Land Council's Stockton Bight land claims, the Dubbo Local Land Council Burke Hill land claim. In all sorts of different places, particular parcels of land have meant land councils were able to grow and prosper. And the Land Rights Act is a number of things, but it's very importantly an economic compensation package, and you just can't hope to achieve social justice without economic independence. The change that's coming on the 1st of July is very significant because it allows the minister determining land claims, which is whichever minister is responsible for the Crown Lands Act in New South Wales. It allows that person to grant a land claim at their discretion rather than factually because it's claimable Crown land. And even more broadly, it allows them to look at other Crown land they might wish to transfer to land councils. So it's a much broader conversation. It could involve multiple land claims being negotiated at the same time. For me, the most important unanswered question is how both government and land councils will organise those negotiations and pay for them. That for me is the most important issue, because if you're going to enter into negotiations or mediation or conciliation about land claims, like any other matter, it's not going to work unless both parties come to the table prepared.